By now, you have seen property management from several angles. You learned the basic functions of a property manager, how management agreements create an agency relationship with the owner, how leases and tenant rights work in practice, and how trust accounts, records, and risk management protect both the public and your license. This section steps back and asks a more personal question. Given everything you know, should you step into property management at all? And if so, how will you do it safely and professionally? This is not just a career preference issue. Property management is tightly tied to agency duties, fair housing compliance, trust account rules, and landlord-tenant law. A careless favor for a client can quickly become accidental property management, with full liability but very little planning. The goal of this section is to help you make a conscious choice, build a support system around that choice, and recognize where your limits are. What property management really is. Earlier, you learned that property management is the part of real estate devoted to leasing, managing, marketing, and maintaining property for others. That definition sounds simple, but in practice, it means you are taking day-to-day responsibility for someone else's investment. The purpose of a property manager is twofold. First, you work to provide the owner with the highest possible continuous net return, consistent with the property's best and lawful use. Second, you provide tenants with reliable service and fair value for the rent they pay. If you focus only on the owner's income and ignore tenant experience, you invite vacancies, complaints, and legal disputes. If you focus only on pleasing tenants and ignore the owner's budget and goals, you may overspend or under-enforce the lease. A competent manager balances both sides within the law and the written agreements. Talk with your broker before you do anything. The first practical step before you take on even one small favor is to talk with your broker. Under earlier agency and supervision lessons, you saw that all licensed activity flows through the employing broker. Property management is no exception. Not every brokerage is set up to handle it. Some brokers avoid property management entirely because of liability, trust account requirements, and the extra scrutiny from the state real estate department. Others allow limited leasing activity but reserve full management to a smaller group of experienced agents or to a separate management division. If your broker does authorize property management, you must understand three things clearly. First, how the brokerage's trust accounts are structured and who can sign on them. Brokers who handle owner funds must maintain properly titled trust or fiduciary accounts, reconcile them regularly, and be prepared for audits. Second, what insurance coverage is in place. Many brokers obtain specific errors and omissions coverage for property management and may also require bond coverage for agents handling money. Third, what policies and procedures exist. Written office manuals, standardized forms, and internal checklists are critical. If your broker simply says, go ahead, but offers no training, forms, or procedures, that is a warning sign. You would be stepping into a complex area with little support. Interview yourself. Are you a good fit for property management? Just because the law allows you to manage property does not mean it matches your skills or temperament. Sales and management rely on different strengths. Sales often rewards persuasion, short-term deadlines, and one-time closings. Management rewards patience, systems thinking, and long-term relationships with both owners and tenants. One important question is whether you have good people instincts. When you meet prospective tenants, you must look beyond application forms. How do they present themselves? Are they respectful? Do they seem honest and consistent when answering questions? Screening is not about judging people superficially, but about noticing patterns that might indicate reliability or risk. Experienced managers often point out that they have handled hundreds of tenancies and only needed to evict a small handful because careful upfront screening prevented most problems. Another question is whether you handle conflict well. Property management guarantees conflict. Tenants call when something breaks, when they are unhappy with a neighbor, or when they cannot pay rent on time. Owners call when they are upset about expenses, vacancies, or tenant behavior. A good manager stays calm under pressure, listens for the real issue behind the anger, and responds within the legal framework rather than reacting emotionally. You must also be able to balance the needs of owners and tenants. Legally, the owner is your client, but you cannot treat tenants as opponents. Many times, you will find yourself explaining tenant rights to owners and discouraging owners from actions that would violate landlord-tenant law or fair housing. At the same time, you must hold tenants accountable for rent, care of the property, and lease terms. If you are uncomfortable telling either side no when necessary, management will be stressful. Finally, do you truly like problem solving? Management is problem solving in real time. A water heater fails on a weekend. A storm damages a roof. A tenant reports mold, or the HOA issues a violation notice. If you enjoy diagnosing what happened, researching options, and executing a solution, you may thrive. If every problem feels like an unwelcome interruption, management may feel draining over the long run. Get educated, law, classes, mentors, and specialty. If you and your broker decide that management is a good fit, the next step is education. Flying by the seat of your pants is dangerous when you are handling trust funds and other people's property. Understanding landlord-tenant law is essential. Residential tenants often have significant statutory protections. Wrongful eviction, mishandling of security deposits, and improper notices can lead to penalties, damage awards, and complaints to the real estate department. For example, taking back possession of a property because you heard the tenant abandoned it without following the legal abandonment procedures can be treated like an unlawful entry. The fact that you have a passkey does not make it lawful to enter without proper notice or cause. You must also fully understand fair housing at both the federal and state level. You cannot refuse to rent, set different terms, or provide different services based on protected classes, such as race, color, national origin, religion, sex, disability, or familial status. Steering applicants toward or away from certain properties, different screening standards applied to different groups, and discriminatory advertising all create substantial risk. Formal classes in property management are invaluable. Many real estate schools offer courses focused on residential property management, lease law, and trust account handling. Some association-based courses also address risk management, fair housing, and best practices. If you are undecided about jumping into management, taking a dedicated class can help you decide with your eyes open. Mentoring and peer networks are another part of your education. Talking with experienced property managers helps you see what the work looks like over time, not just in theory. In seasonal markets, for example, you may find that most turnovers and leasing activity happen in a few intense months each year. Observing an experienced manager during the busy season can show you how they schedule vendors, handle multiple move-ins and move-outs, and keep records straight. Property manager networking groups and professional associations provide a place to ask questions, share challenges, and get practical advice. Choosing a specialty is wise as well. Residential management can include single-family homes, small plexes, larger apartment communities, or vacation rentals. Each has its own patterns and expectations. You may decide that you are most effective with mid-range, single-family homes, or that you prefer the systems and staff structure of larger multifamily properties. Focusing on a slice of the market makes it easier to design consistent procedures and marketing. Developing a plan, policies, legal counsel, and preparing for surprises. Earlier sections on risk management emphasize the importance of written policies and procedures. In property management, those procedures should reflect landlord-tenant law, fair housing, trust account rules, and your management agreement obligations. Well-designed tenant screening standards are essential protection. A consistent policy outlining income ratios, credit standards, rental history, verification steps, and how you will use criminal background information helps you treat applicants fairly and avoid claims of discrimination or arbitrary decisions. Importantly, modern fair housing guidance expects landlords and managers to use criminal history carefully, avoiding blanket policies that exclude all applicants with any record and instead considering the nature, severity, and age of the offense in relation to the risk to residents and property. A written screening policy that reflects this approach helps you avoid unintentional discrimination. Specialized property management software can help you track rent, late fees, repairs, and communications. Software does not replace judgment, but it does reduce the risk of lost invoices, forgotten late notices, and trust account reconciliation errors. Legal counsel is another pillar of your plan. The lease and the property management agreement are the key contracts that define everyone's rights and responsibilities. Because landlord-tenant law is detailed and sometimes vague around the edges. You should have an attorney familiar with property management review your standard forms regularly. For example, general language such as "the tenant shall not destroy or waste the property" may need more detailed clauses to address landscaping, pool care, or appliance use. Your management agreement should also state, in writing, how much you may spend without owner approval and what process you will use to get authorization for larger expenses. Preparing for the unexpected means thinking in advance about scenarios that feel urgent. What if police activity occurs on the property and you are asked to evict immediately? What if a tenant's pet injures someone? What if an appliance you advertised in the listing fails? In general, if you market a feature, you're representing it as part of the rental, and the owner should expect to repair or replace it during the tenancy. If you wish to exclude an item from being a landlord obligation, that exclusion must be clear in the advertising and the lease. Having written decision trees or checklists for common crises reduces guesswork and calms everyone during stressful moments. Reaping the rewards. Why some agents love management. Despite its challenges, many licensees find property management rewarding. It can provide a steady income stream that is less sensitive to short-term sales cycles. When the sales market slows, rental demand often grows as owners decide to lease instead of sell, and as renters seek housing after foreclosures or credit events. Management also allows you to meet client needs in a broader way. When a seller cannot obtain their desired price, you may offer management as a way to generate cash flow until market conditions improve. Investors, builders, and owners of second homes often prefer to work with a manager who understands both sales and long-term asset value. Establishing a property management niche can differentiate you in a crowded real estate field. Some brokers even treat property management divisions as separate, saleable businesses built over time. A portfolio of well-managed properties with written procedures, records, and owner relationships can have value beyond month-to-month fees. The reality, however, is that down markets and economic stress can increase management headaches. More tenants struggle to pay rent, more owners delay needed repairs, and more properties may face foreclosure or short sale. A strong management plan, clear agreements, and solid communication make these periods manageable, but they do not eliminate the stress. Recognizing this upfront helps you set realistic expectations, knowing when to say no thanks. It is equally professional to recognize that property management is not for you. If, after honest self-evaluation, you decide that the legal complexity, constant conflict, or trust account responsibilities do not suit you, the best decision may be to refer management opportunities rather than take them on. Referring business to an experienced property manager still allows you to serve your clients. You can help them by connecting them with reputable firms, often based on recommendations from attorneys, your broker, or professional organizations. Some managers belong to specialized associations dedicated to residential property management and handle thousands of units. These firms may offer referral fees within legal limits or simply become strong reciprocal referral partners when owners later decide to sell. Even if you do not manage, you must resist the urge to give management advice outside your expertise. For example, you should not advise owners on whether to form an LLC, how to structure depreciation or landlord tax strategy, or what legal clauses to include in a lease. Those questions belong to attorneys, accountants, and insurance professionals. Your safest and most ethical answer is to encourage clients to consult the appropriate professional. You should also avoid accidental property management. If you are a listing agent and you start turning utilities on and off, paying vendors, and coordinating pool service or yard care without a written employment agreement, you may have taken on management duties without realizing it. Instead, if you are going to perform those tasks, you should have a written agreement that outlines your authority, what will be reimbursed, and how liability is handled. Without that, you may be exposed to responsibility for injuries, unpaid bills, or property damage without clear compensation or protection. Case examples: applying the rules in real situations, unlicensed assistance, and rent collection. Imagine a licensee who manages several rentals and instructs tenants to bring rent payments to an unlicensed assistant at the office. The assistant counts the money and issues receipts. Under state policy on unlicensed assistants, this is not permitted. Collecting rent, agreeing to collect rent, or issuing receipts for rent are licensed activities. The assistant may perform clerical tasks, but cannot stand between the tenant and the broker in the collection of rental payments. In practice, the assistant might accept sealed envelopes and immediately hand them to the licensee, or deposit them in a locked box, but they should not be the one who receives and accounts for rent, keys, possession, and tenant liability. Consider a tenant leasing a furnished condo that includes a flat-screen television. At the end of the lease, the tenant calls the property manager to say, "I left the keys on the kitchen table." When the manager enters the unit later, the keys are missing and so is the television. Under typical lease language, the tenant remains in possession and liable for damage until the keys are actually returned to the manager in the manner specified in the lease. Leaving the keys inside without agreement does not count as proper return. The tenant is likely responsible for the missing television and any other damage until lawful surrender of possession occurs. Marijuana cultivation in a rental. Now imagine you manage a luxury rental and discover that the tenant is cultivating multiple marijuana plants inside. The tenant is otherwise current on rent and appears to believe they are acting lawfully. Your first duty is to notify the owner. The owner's rights will depend on state law and on whether the tenant is a registered medical card holder. But there are some consistent themes. If the tenant has no legal authorization, cultivation is typically a form of drug-related criminal activity and may allow immediate termination of the tenancy and an accelerated eviction process under the lease and landlord-tenant statutes. If the tenant is a cardholder, their status alone is not a legal basis to refuse to rent or to evict. But cultivation inside the rental may still violate the lease or state law. The key point is that a manager should not attempt to navigate these subtleties alone. The owner should be advised to seek counsel, and any eviction should follow the exact legal procedures to avoid wrongful eviction claims. Record retention duties. Suppose a landlord demands receipts for every repair over the last 5 years due to a dispute over costs. Management statutes often require property managers to keep all financial records relating to clients for at least 3 years from the date each document was executed, including bank statements, check images, deposit slips, receipts, ledgers, and invoices. The manager is not required to keep or produce records beyond that statutory period unless the management agreement says otherwise. Knowing and following the 3-year minimum protects you during audits and disputes, and it also allows you to set realistic expectations for owners about what can and cannot be produced years later. Licensing requirement for management companies. Consider a small company that manages several apartment complexes for a single owner. The company leases the units, advertises vacancies, negotiates terms, and assists in procuring tenants. Even if the company has only one client, it is engaging in real estate activity for another and for compensation. Under the statutory definition of broker, this company must be licensed as a real estate brokerage, with a designated broker responsible for compliance. Operating without a brokerage license while performing these activities can lead to enforcement action for unlicensed practice, returning owner funds after management ends. Finally, consider a management agreement that is mutually terminated in June. The owner demands that all funds in the trust account be paid out immediately, but the manager knows there is at least one unpaid contractor invoice. Statutes often require the property management firm, upon termination, to provide a list of all tenant security obligations within a short period, such as 5 days, to reimburse all remaining owner funds from the trust account within a set period, such as 35 days, except for monies needed to pay obligations incurred during the agreement, and to provide final receivable, payable, and bank reconciliation reports within a longer timeframe, such as 75 days. The manager may therefore hold back a reasonable amount to cover known unpaid bills, but must remit the balance within the statutory deadline and document the final accounting. Security deposits and trustees' sales. Another situation arises when a rental is scheduled for trustees' sale. A broker may terminate the property management agreement when the sale is noticed, but cannot automatically refund the tenant's security deposit just because the management agreement ended. Unless the owner authorizes otherwise, or the lease form specifically addresses an actual completed trustee's sale, the broker must hold the deposit according to the lease and management agreement. Terminating the management relationship is not the same as termination of the tenancy or extinguishing the tenant's rights in the deposit. Review summary. In this section, you learn to treat the decision to enter property management as a deliberate professional choice, rather than an accidental extension of your sales business. You saw why the first step is always to talk with your broker about whether the brokerage supports management, what trust account arrangements and insurance are in place, and what policies will guide your work. You learn to interview yourself by examining your people instincts, conflict management skills, comfort with balancing owner and tenant interests, and appetite for day-to-day problem solving. You saw that enjoying systems and long-term relationships is as important as enjoying real estate itself. You explored education pathways, including studying landlord-tenant law and fair housing, taking specialized property management courses, seeking experienced mentors, and focusing on a particular niche like single-family rentals or small apartment buildings. You also learn to build a plan that includes written policies, careful screening standards, appropriate software, regular legal review of your forms, and advanced thinking about common crises. You then considered why many agents find management attractive. It meets client needs in new ways, can provide steadier income in down sales markets, and can create a distinct professional niche. At the same time, you saw that it brings unique stresses, especially when the economy tightens. Finally, you studied when to say no to management work, how to refer clients to reputable managers, why you must avoid giving legal or tax advice outside your expertise, and how to prevent accidental management arrangements. Real-world examples illustrated how unlicensed assistants may not collect rent, how possession and key return affect tenant liability, how marijuana cultivation in a rental triggers complex legal questions, how long records must be kept, why management companies must be properly licensed, and how and when owner funds and deposits must be returned. Discussion prompt 1. A longtime sales client asks you to just keep an eye on their vacant rental house by turning on utilities for showings, paying the pool company from rent, and collecting rent checks in your office. There is no written agreement, and your broker has not been consulted. Based on this section, What problems do you see, and how should you respond? Suggested answer. You should recognize that this request would place you in the role of property manager without any written authority or protection, and without confirming that your broker supports property management. You would be handling rent and paying vendors, which implicates trust account and licensing rules. You should decline to proceed informally and instead talk with your broker. If your brokerage does not manage property, you should refer the client to a qualified property manager. If your brokerage does manage property, you should enter into a proper written management agreement and ensure that all funds flow through a designated trust account and that you follow office policies and statutes. Discussion prompt 2. A tenant moves out and tells you they left the keys on the kitchen counter. When you enter days later, you find damage and missing items. How does the concept of possession and key return affect the tenant's liability? And what should your documentation and procedures look like? Suggested answer. Under typical lease language, the tenant remains in possession and liable for damage until the keys are surrendered in the way the lease specifies, such as returning them to the property manager or office. Simply leaving keys inside the unit without agreement generally does not count as proper return. You should have clear lease clauses about how possession is surrendered. Document the move-out inspection with photos and a written condition report, and send a security deposit disposition letter that explains any deductions and the reasons based on the lease and state law. Discussion prompt 3. You are considering adding property management to your practice, but you are unsure whether you are suited to the work. How could classes, mentoring, and a temporary part-time arrangement help you decide? Suggested answer. You could enroll in a property management course to study the legal requirements, trust account rules, and common issues. This would expose you to the complexity of the work and help you see if the subject interests you. You could also seek a mentor who already manages property and ask to shadow them during busy periods, perhaps helping with move-in and move-out checklists or maintenance scheduling under supervision. A part-time role within an established management firm would let you experience conflict, emergencies, and routine tasks before committing to your own portfolio. These steps allow you to test your skills and preferences in a lower-risk environment. Closing remarks. Property management is a powerful extension of your real estate license, but it is not a casual sideline. It demands strong systems, a clear understanding of law, honest self-assessment, and constant communication with your broker, owners, and tenants. Used wisely, it can deepen client relationships, stabilize your income, and expand your expertise. Used carelessly, it can expose you to complaints, legal disputes, and license discipline. As you move forward, remember that good property management starts with a clear yes or no based on your skills, support, and education. You are not just taking care of properties. You are taking care of people and protecting their investments and your own professional future.